What's up, everybody? We are finally talking about the Corey Richins preliminary hearing. It's something everybody's been waiting for. What does the state have? What are they going to prove? How do they present it? What does a preliminary hearing look like? A lot of people have never seen one. We were waiting for one in the Koberger case. Now we know. That's going to be the big thing. Is we're going to talk about what exactly happens at preliminary hearing and what it all looks like. Is it what you expected? That's what I want to know from you. Let's get into it. Make sure you hit the like button and subscribe if you have not already. So as we get into the last, day and a half of this preliminary hearing, we're going to watch some clips, just a couple clips here and there of the evidence that was presented. We're going to talk about how it was presented, what the state said, how they did it, the arguments made by the state, the arguments made by the defense. I'm going to summarize a lot of it, and then we'll try to watch what the judge said. I'm trying to find clips of it because that's one of the takeaways from this trial and this preliminary hearing is this feed kind of sucks. The audio sucks. It's hard to actually find the full hearing in different places. Day one, I found and listened to fine. Today was so hard to find the arguments. I had to listen to a snippet here and a snippet there, which was annoying, but some new information and some pretty damning information that the state has against Corey Richins. But is it enough for all the charges? Because in a preliminary hearing, this is the opportunity for the state to present the evidence they have to the judge and for the judge to determine in a light most favorable to the state, giving them all the reasonable inferences. Do they have enough to prove probable cause? Not guilt beyond a reasonable doubt, but probable cause. And one of the reasons I think this is such an important video to watch and hearing to watch and learn from for all of us is so many of you had questions about the preliminary hearing in Koberger, how it was so unfair that it didn't happen and they went to a grand jury and that seems shady and it's not fair. And I get it. And there are elements of that. But as if you watch this, you'll see a preliminary hearing is not a trial. The standards are different. The rules of evidence are different. The way you present evidence is different. The judge makes the call and they most commonly end the same way and they end the same way that this one ended. I'm not going to spoil it yet. We'll wait till we hear the judge's ruling. I actually really like the way the judge laid out his ruling and I agreed with it. But just because a preliminary hearing doesn't happen in a case like Koberger does not mean that that person is definitely innocent. They for sure would have won the preliminary hearing, and it was so unfair that the prosecutors decided to go another route. Additionally, it does not mean we would have seen every piece of evidence the state has. It does not mean the defense would have been able to do discovery depositions with every single witness the state puts on the stand. There's a lot of summary evidence. The judge could potentially limit the testimony that can come in and the way the questions can be asked and the way the defense can argue. And some of it just doesn't work at a preliminary hearing like it does at trial. So to start out, we are going to talk a little bit about the way the evidence was presented. They started later than expected. I mean, they said this was going to last 2 or 3 days. It barely lasted more than a day if you combine the actual court time that we got to see. But the state said they're going to have 3 witnesses, the detective and 2 experts. Okay? And the detective and 2 experts that are going to testify for the state are going to be the entirety of the evidence. And the detective that's going to testify for the state is not actually going to testify for the state. They are just presenting him for cross-examination by the defense because everything he already testified to in the detention hearing and everything that's in all the documents they presented, the probable cause affidavit, the text messages, the Celebrate report, all that stuff, all the evidence, all the documents, the discovery that they've already given to the judge can consider in this preliminary hearing. Which means we don't get to see a lot of it presented. We're going to talk about some that was presented in the argument, but we don't get to see a lot of it. We don't get to see a lot of it again. We already saw a lot of it in the prior hearings that a lot of these witnesses already testified to. But let's hear the state explain exactly what they're going to do with this detective.
The state is essentially offering Detective O'Driscoll for cross-examination by current defense counsel within that scope as in the best interest of a fundamentally fair proceedings. They've not yet had an opportunity to cross-examine. The state provided the defense with advance notice of this approach and reserved the opportunity to redirect. Finally, Your Honor, I'd like to, I guess by stipulation, admit a few more documents.
So he admits a few more things, more for the state to, for the defense to cross-examine him on and for the judge to consider. And so the new defense counsel gets to cross-examine this officer. They point some things out like, do you really know it was fentanyl? Were any drugs found in the home? And they did talk about, they make some interesting points here about some THC that was found in the home. We'll listen to a little bit of that. Then they talk a little bit about the interview with Miss Richins. We'll hear a little bit of that and whether or not it seems like was her right to counsel violated. Did they handle all of that appropriately? So let's listen to a few minutes of this.
Were they in the form of gummies or some other form of THC? They were edibles. So were the edibles, were you made aware, or are you aware of who the edibles belong to?
Were you aware of who the edibles belong to? The THC gummies?
We received statements that they belong to Eric for this evening.
Were those edibles tested?
Yes.
And did you review a report regarding those edibles?
Yes.
And did that report, that initial report, say that there were traces of fentanyl in those edibles?
No.
You did not review a report that said there was fentanyl in the edibles?
No.
People are saying there's no sound. Okay, so I don't know why that's happening. There's no sound. Okay, let me see if I can figure that out. I have no idea why that would happen unless some settings were changed here. All right, I guess we can just summarize then. If there's no audio coming from the court, which is annoying. There is sound, it's just very low. Okay, it is incredibly low. I already have it boosted. Boost it as much as you can. I'm just going to play a couple minutes. We're not going to play a ton of it. Literally just 5 minutes are we going to play from this clip, and then we're going to move to another clip. So I'm just going to play it really quick, summarize a lot of it, and then we'll just keep moving on. I get that the audio sucks. I mentioned that off the top.
So as you were investigating this case, well, let's start that. I'll come back to that. So you talked about that your first interview in this case was with Corey Richins. What was the date of that interview?
I believe it was April 14th of 2023.
So this was about 13 months after Mr. Richins' death.
Correct.
All right, we don't need to listen to it. I can just summarize it. Forget it. I'll just summarize this day. Some of the other ones are a little bit better, so we'll listen to some of the other ones. Somebody said Emily's audio was better. I'll see if I can pull a clip from hers, maybe, because I do want to hear the judge's ruling. Maybe we'll pull that from hers. I got a little clip from the lawyer argument. No big deal. We'll summarize the evidence, okay? Because there really wasn't a ton. There wasn't a ton to get out of it. There wasn't a ton that we heard with witness statements. The defense kind of hinted that they would call a witness or two potentially, and they didn't end up doing that. So this went so much quicker, I think, than anybody expected, but we kind of got hints of that at the hearing prior to this. So other things they brought out is that the alleged drug dealer in this case, she kind of went back and forth. They impeached her a little bit. They threatened her with criminal action. They told the DA that she was cooperating. That probably affected her testimony. Can we really believe her testimony? And again, a lot of that stuff may affect the jury. It may make them think that she's not credible. It may impeach her credibility. They may think she's a drug dealer potentially. Are we going to agree with her? She got potentially a deal to testify against Corey Richins. None of that's really going to affect the judge because at this point, he's going to take everything with positive inferences toward the state as if it's true, a light most favorable to state, whatever kind of language you want to use. But at the end of the day, she said what she said. The drug dealer testified enough to give them the information that they needed here. Okay. The officer also talks about how there were other witnesses that corroborate I already have it, Kelsey. That corroborate the drug deal, how it took place, where it took place, that Corey went out there. And there's plenty more on that we're going to talk about later. Then on redirect, even though there was no direct, the state did get up talk about the difference, because one of the things that the defense brought up when they were cross-examining the officer is that wasn't fentanyl found in these THC gummies? Weren't they laced with fentanyl? And the officer was like, I don't remember that. Prosecutor got up and talked about fentanyl being indicated versus found, and how it was indicated here but not found, and how that means it was possible. Again, seems like an argument that may work better in front of a jury, and that a jury may think that maybe Eric took some bad gummies, or maybe he did do some drugs or something, and that was included in all of this. And maybe that would be a good argument if there was less of the other information that we're going to talk about later, like Corey Richins' own statements, which we always know there is no better evidence against somebody than their own statements, which there are plenty of in this case. On recross, they get out how some of the information potentially driving to and from somewhere wouldn't have been recorded, but all of the information about this case was recorded. And again, they ask about, do we know that the pills or whatever was given from the drug dealer to Corey actually went to Eric? And he's like, no, I don't know, beyond a shadow of a doubt necessarily. Do we know that nothing was switched while it went from how the drug dealer got it to it going to Corey to it going to Eric, and how it changed all these hands? Do we really know it was fentanyl? Do we really know that he got it? And it's like, yeah, with all of the circumstances surrounding it and the toxicology report at the end, and we know we have the attempted crime and the crime itself, the first degree M. And so, yes, we don't know because we don't have a chain of custody. And when we're talking about chain of custody and evidence, that's basically what the defense was trying to make it seem like with this, the drugs passing hands, is we don't have a chain of custody report that, yes, we knew it was fentanyl here. When it got to the drug dealer, yes, it was fentanyl. When it got to Corey Richins, yes, it was still tested positive. And then when she gave it to Eric, yes, it was still tested positive. No, we don't have something like that. We almost never have something like that in drug deals. So, but they're trying to point out that it could have instead been something else. Then take a lunch break. Then we get the expert witness. That's the investigator. Again, all these people testified at the prior hearing. They went through some of his background and experience, talked about the cell phone data that he got from her phone. And again, this was just kind of laying the foundation because the judge has the text messages, the Cellbrite report. On cross, I thought there were some pretty good shots at his expertise and credibility, potentially. Nowhere near enough to make any effect on a preliminary hearing. Because they talked about how he hasn't been recertified since 2017 in Cellbrite, and how things are changing. And certain things are not the same as they were before, the way that things are used. Certain things are unreliable, which again, we heard from Karen Reed, how that stuff's always changing. And I am wondering if this defense team is going to use some of those arguments we heard in Karen Reed here to try and some of the arguments the prosecutors made in Karen Reed, right, about how the Cellbrite report was inaccurate here and there. If other lawyers like these defense lawyers are going to use those same arguments, I kind of think they will. Then we get to the forensic accountant. And to me, this is some of the most damning circumstantial evidence, some of the most damning evidence of motive, right? How Corey Richins was leveraged to here, and how the way the prenup was, Eric was worth more if he passed rather than if they got a divorce. And how she needed the money and he wasn't necessarily letting her buy the investments she needed. She flipped a few properties. The defense on cross made it seem like it was successful because she was able to sell those flipped properties. We didn't really get into some of the details of it, but at the end of the day, the state made it seem like they were not successful flips but the accountant kept saying things like, well, if you consider selling the property successful, then it is successful. But what if that's not how you measure success? And she kept talking about how she doesn't know how she measures success. It's like, come on. We've all seen flip or flop. We know how to measure success. Did you make money? What was your net gain from buying, paying to remodel, and selling the house? Come on, tell us. Were they positive? Were they not? But at the end of the day, it really seemed like they were not successful flips because she was leveraged. She didn't have enough money to pay her debts. And again, life insurance policies were taken out at inopportune times, and they are more likely to get investigated when somebody passes very soon after a new life insurance policy is either taken out or increased amounts. Okay. So she goes through all that. To me, that's very damning evidence. I like the way that lines up for the prosecution, for them to be able to explain what the motive is, because in so many cases, Juries want to know motive. You don't have to prove it, but it's always easier and better if you can prove motive, obviously, right? All right. So that was basically the evidence. Okay. Took a couple hours, not a ton, but the bulk of the evidence the judge considers, and that's why I really want to listen to the judge's ruling. Yes, there's a murder one charge, there's attempted M, there's distribution charges, and there's financial charges that we're going to hear. The judge will delineate all of them when we hear the judge's ruling on whether or not probable cause was established here. John said, sweet seats. You should host a guest there. So I don't know if now is a good time to pause and vent to you guys. Maybe I will vent about what's going on behind me at the end of the podcast. Okay. Or at the end of the, I should say, live stream. Freudian slip there. But remind me somebody to talk about that at the end. I don't want to bore anybody that's just here for Richins with that stuff. And all the real OGs can stick around at the very end. There's another Sarah Boone letter. All right, somebody send it to me. That'll definitely be on the list this week. Okay, so that's a preliminary hearing, not a ton, but I do want to hear, so a ton of evidence for the M1 charge. Everybody seems to agree with that. Even the defense barely made an argument at the end for that charge, but there was some decent argument about the attempt. And the state basically says the best evidence of the attempt is the M itself that happened shortly after. And then text messages that she had that said certain things. Okay. So before we listen to the defense's argument, because I want to play a little snippet, I always think it's interesting when defense lawyers basically know they're going to lose. How do they argue? When they have good arguments that they know they're probably still going to lose, how do they argue? And that's what I want to listen to when we hear this defense attorney argue against the attempt charge. So when I talk through the state's argument, a big part of it is based on the judge's questions, because the judge is the fact finder. We talk about in appellate cases, when you have a panel of appellate judges, they're the ones that are asking questions, and what they're asking questions about usually is what they find most important or concerning, or trying to make decisions based on the information that's available to them. Okay. And when they have information and there are gaps or there are issues that they need, they're going to ask questions, and you've got to provide them with answers as the lawyer. So as we get through the state's argument, there's a couple of very important things I want to point out. And a lot of them have to do with the attempt charge. So texts were coming through saying, some things back and forth on Valentine's Day. She brought him a bagel breakfast sandwich. There was some discussion whether it was lunch, breakfast, not that important, but he starts feeling sick after. And he texts her and says something like, I'm sick enough to go to the hospital. And how does she respond? Okay. And what does this response make you think she feels? She says, take a nap. Now, that may be horrible. I think that's absolutely horrible. I don't know Eric Richins. I don't know if he was a hypochondriac, if he went to the hospital all the time. Maybe it was usually no big deal and he would over-exaggerate. Maybe he was dramatic. I don't know. I will say there are certain people in my family that when they tell me something is wrong with them, I am like, oh, again, or a little eye roll or a chuckle because something's always wrong, right? We all have those family members probably. But when it's your husband and he's saying he's sick enough to go to the hospital and you respond with take a nap, it's not a good look. And a lot of these text messages we're going to talk about were deleted by Corey Richins, and the state says that's consciousness of guilt. Judge isn't necessarily so sure what is or is not consciousness of guilt as these parts, but is it important? We'll find out later. But then we have text messages to Corey Richins' lover that say, if Eric Richins could just go away, life would be so perfect. That text alone, okay? That text alone will probably be enough for some jurors to convict her. She's presumed innocent. She is absolutely presumed innocent as she sits here today, regardless of what the judge decides. And he'll talk about that as well. But if I am trying a case and you hear in jury selection that the defendant over there is presumed innocent. The state is alleging that she took the life of her husband. Okay. Poison may be involved. Life insurance policies may be involved. And then I start opening statements with, this defendant texted her lover that she had a relationship with during her marriage to Eric Richins, the victim in this case, and just shortly before she took his life, this is what she texted to her lover. He would just go away. Life would be so perfect. Now, regardless of what the law says, that the defense doesn't have a burden of proof, now it kind of feels like they've got to prove she didn't do it. How did he pass? How did this happen if it wasn't her? Because her life just would be perfect if he went away. And guess what? He went away. And they've got some more evidence to prove as to why it was her that did it. But having the defendant's own words are so damning. That's not all. There's more. Life is going to be different. I promise. Hang in there till Friday. And who is this text to? Corey Richins' lover. Who's it from? Corey Richins. That's not great. But wait, there's more. So this one, I don't have a direct quote because the way the state argued it, it sounded like it came from Corey Richins' journal. It didn't seem like it was a direct text message. So let me explain how the state kind of argued this, okay, to paint the picture for you. There are entries in her journal and maybe conversations with her drug dealer and her best friend and her lover that all combined go something like this. Corey Richins committed the attempt on Valentine's Day, February 14th. It didn't work. She determined that the amount of fentanyl she put in food wasn't enough because he could take a bite, maybe feel some effects, stop eating, go take a nap. Because that happened, according to the state. But then she determined she needs something much stronger. And he needed to take it all at once. So she told the dealer she needed something stronger, corroborated by the dealer. She gets something stronger. She puts it all in a shot, which is something people take at once, prepares the shot for Eric. Eric takes it all at once, and boom, ends his life. But how do we know that it actually was something stronger and that it got into that shot and eventually got into Eric? The toxicology report, which shows 5 times the lethal amount of fentanyl found in Eric Richins' system. The opening statement and closing arguments literally write themselves, and who wrote them? Corey Richins. She wrote them. Her text messages, her conversations, and her journal entries. Now, this all came out in the state's argument, okay? Because these are all parts of documents and evidence that they presented and gave to the judge. Of course, we have the financial motive and things like that, but her own statements to me are some of the most damning statements I've heard in a case. And Serenity, great point. Divorce him. She could have, but the state's got an answer for that too. She does, and I believe the accountant testified to this, the expert. She does considerably better financially if Eric passes away versus they get a divorce because of the prenup. Yeah, I hear everybody saying divorce, 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 divorce. Well, the state has evidence as to why that would not work in Corey Richins' plan. They also have the house she was flipping and the millions of dollars she needed to flip the house and how it was her dream and she wanted to do it and Eric didn't. All that stuff's going to come out of trial. It didn't come out specifically, in the most salacious way in a preliminary hearing because that's not what happens in preliminary hearings. And I think that we all learned preliminary hearing is not as exciting as a trial necessarily. It doesn't connect all the dots like a trial does. The judge is given things we don't see, and then the judge makes the decision. So for people that, thought they missed out on learning a bunch of information from the Koberger preliminary hearing, I think it would have been very likely that either some of it was given to the judge that we never saw, some of it was done behind seal or behind closed doors, under seal, I should say, that we wouldn't have seen. And I think this gives us a little indication of that. Now, some preliminary hearings are more robust, and judges, there was multiple times throughout this one that the judge was like, hey, this isn't a discovery depot defense. Ask questions that specifically deal with probable cause. And you would ask, how does this deal with probable cause? How does this go to probable cause? And so I appreciated that. But now let's listen to a few minutes of the defense arguing why that attempt charge is weak, and why even if the judge finds probable cause on the other charges, financial crimes, even the M1 charge, why attempted murder is not one the judge should find probable cause for. And again, I like to hear lawyers make arguments, craft arguments. How do they do it, especially in difficult positions? And we're going to listen to a little bit of this lawyer's argument. This is one of her defense lawyers.
It's their opinions, it's their beliefs. They're not a grand jury, they're prosecutors, they do their best. So what we have created to protect clients from that awesome power that sits at that table is this process of a gatekeeping. That instead of delegating that to a grand jury, people in our society that come together and close doors and hear the evidence and decide whether there's enough to put someone through this, they bring it to you. You're the gatekeeper. And this preliminary hearing is a critical right that every single individual who they decide to write a charge against has. And when we come before you, we recognize that it's a low standard. We recognize that probable cause means that. It just means enough to charge you. It doesn't mean enough to convict you. It doesn't mean enough to determine you committed a crime. It's enough to charge you. But that charging decision does matter. And it's going to have a huge, huge impact on the way this case plays out, on the evidence that is brought before the jury, on who will be witnesses, determining what charges get past this gate, you the gatekeeper. So we believe very, very, very strongly that the charge of attempted murder has not met the lowest standard even of probable cause. And that as rare as it is for a judge to say there's not even enough to charge here, it is anticipated that that will happen on occasion, which is why you do thousands of these, right? Because every once in a while, they don't get up to that level. And we think in this case they haven't done it, and we'd like to tell you why. So thank you for indulging me.
I agree with everything you said about the law. And what is the essential element of count 2 that you believe the state has either shown no evidence of or insufficient evidence to draw a reasonable inference for her?
Causation, 100% causation. So in order for them to establish an attempted murder,
Right.
They have to show that Ms. Richins took some act that caused someone to be in danger of death, right? She had to cause something that put them at risk, right? Whether they actually died, obviously it's attempt, right? So I think it's critical that you understand the timeline of that day. And I want to walk you through, and I know it may take us a couple of minutes, but I think it shows so clearly that they cannot make the connection. And
She thinks it so clearly, right? So the certain hyperbole when you basically know you're going to lose is always interesting in the back of my mind. Now, some people may watch this and be like, oh, maybe they're going to win. They're not. Okay. Spoiler alert. But I think there was some wiggle room here in this attempt charge. And I'm thinking to myself, like, what do they really have if not for the actual ending crime that does happen? And will the judge think that the end crime where she actually accomplished her goal, is that enough to prove the attempt that happened before?
indisputable evidence that's in the Celebrate that has been downloaded off their phones. There's no debate about what happened on those phones. Okay. So in Exhibit 6, there are substances of text between Eric and Corey that say exactly their communications that day. I want to go back to the very beginning, which is the receipt, which is Exhibit 66 from the Mirror Lake Diner. It shows that Corey's credit card swiped at 9:07 a.m. and that she ordered a bagel breakfast sandwich and an omelet. There is a statement under the sandwich that it's over hard, which means it's an egg sandwich. There's an egg in that breakfast sandwich. And I think that's important because I don't know about you, but I'm not eating an egg sandwich 2 to 3 hours after it's brought to me. You eat it quick or you don't eat it. So she brings an egg sandwich home at 9:07. This actually hasn't come in, but I think the court could take judicial notice because of the address on Ms. Carrington's exhibit.
I'm going to skip ahead just a little bit. They talk about, was it an egg sandwich? Was it breakfast? Was it lunch? It's confirmed it was an egg sandwich. I think they had a receipt, a bagel sandwich, something like that. And the timing of it all. She's trying to say too much time went by. It wouldn't have happened like this. And some of it makes sense. Some of it is good argument. The point is, how do we know that she put fentanyl in the egg sandwich and that's what caused Eric Richins to feel the way he did and take a nap, right? Without knowing what happened later. Like, in reality, we all know this. This never would have been charged if the final crime wouldn't have happened.
The locations of calls made by Eric.
Could you pause for a second?
Yes.
Is there a statement that they ate breakfast together?
They just talked about her telling her friend lying that they were together when they ate.
So I just want to make sure I'm not missing anything that you're seeing. Quote, forgive me, folks. I didn't even make him a fucking sandwich this fucking idiots. It was Valentine's Day, and Eric and I both were working from home that day, and I ordered lunch from Mirror Lake Diner.
So yeah, he dropped some F-bombs there. Sorry, I didn't know that was coming. I knew he did it kind of multiple times, but this was just them trying to figure out, was it breakfast, lunch? It didn't end up being important in the end.
And then says a few minutes later, so between 11:27, he's talking about soccer, and 11:33, so he hasn't seen Corey now in 2 hours. He says, I'm gonna go lay down if I don't feel better and I go to the hospital.
So again, and this is why this connects, okay, because they're talking about the timing. This connects to maybe some THC gummies. Were they laced with fentanyl? Did he just take some THC gummies and he had this effect and that's why he got tired? There are other presumptions and things that can happen, right? There are other things that could have happened other than she tried to do this. We have to forget about some text messages we know about. But again, let's listen to the lawyer make the argument.
And I must respectfully point out that when the prosecution talked about her saying, go take a nap, and how that was chilling, he pulled that completely out of context of the rest of what she said in that text. Would you like me to come home? Jesus, is that bad? You know, she even at one point later in the day talks about, I wish.
I also agree with her there. Would you like me to come home? Jesus, is it that bad? That adds a lot of context to just go take a nap, especially the way the prosecutor, with the pause and the way that he did it and the way that he described it. So you got to be careful as a lawyer when you've got the goods. Don't mispackage them for people to make it look like you're trying to pull one over on them and you're trying to twist things. Who cares? Say she was really concerned about him. She's like, do I really need to come home? Go take a nap. Could have couched it that way to at least give it the whole, so that the judge cursed. Okay, the judge cursed reading a text message from Corey. That's why. He did not curse on his own and he apologized for saying it. Just FYI. Yes, I really like this judge as well. Really like him. And we are going to hear his comments. I have Emily's video, who she seems to have great streams always. Somebody said she got it from Recovery Addict. Great streamers. Love the trial streamers. They're the best. So we're going to listen to hers. We get to see her face on our stream as well. That's always good. That's how we're going to get the judge's comments. Again, I had to go everywhere to get these clips. Was kind of annoying today, but more of the defense's argument here.
You're here, and she's like, I would cuddle you. So that is very misleading to pull that statement out, and I need to correct that for the record. But regardless, now he hasn't been in her presence for 2 hours. If he ate that sandwich, he ate it around 9:30, give or take, at the latest. So in that period of time, he's been running errands, doing business calls, texting Corey, very benign, normal day-to-day texts. Nothing about I'm about to die, nothing like that. He takes a nap for 2 hours. Then he gets up. They text romantic text, wish you were here, like to cuddle. That's at 1:43 when he just woke up. The same period of time well, I'm sorry, that's not before. I withdraw that.
So it also definitely at the time feels like Eric didn't think it was her, but duh, right? Later, maybe he did, and he said it, but at the time he didn't, but that doesn't prove that it was an attempt. But again, making an argument.
Continues to make work calls from 1:50 to 2:30. Goes to a soccer game with his kids from 3:52 to 6:11. Takes the boys to get some food. Leaves food for Corey in his truck as they go back to the game because Corey is running late. And that's the day. That's the day that they're now saying that you can infer she tried to murder her husband. There's no evidence he ever took a pill from her. There's no evidence that she ever if she put fentanyl in his egg sandwich at 9:30 and he ate it, he would not be okay for 2 more hours. He would not be. And
again, she's making an argument. I would think that you may want to provide an expert that can say that. And we're learning some of their, we're learning that some of their trial strategy is going to be based on these arguments. Recovery Addict ended up having the only stream. Isn't that awesome? Don't you love when something like that happens? I wish I would have known that earlier. It would have saved me a lot of time this afternoon scrambling the last hour before the show started. I had a miserable day today. So, yes, Emily Baker is a lawyer that also streams trials, as is Recovery Addict streams trials, not a lawyer. At least not that I know of.
Zero evidence. There's not one piece of evidence from Eric himself that he ever took anything from Corey that day, that he felt bad up until 11:33 is the first time he feels bad. Now, I think you asked a fascinating question when you asked the prosecutor, do I need to consider the death as support for probable cause of February 14th looking backwards? And I think that's a really important inquiry because obviously, if you look backwards, everything you're looking backwards at shades how you look at something that happened before. But if you look at that count in isolation, there is no evidence that supports an opportunity for her. There's no evidence to support that he took anything. There's no evidence to support that he had fentanyl.
She's saying there's no evidence to support that he took anything, but he ate a sandwich she gave him, just like he drank a shot that she gave him. And again, you notice how like it's hard for defense lawyers as they're making these arguments. Like, of course, if you start with the actual crime that she committed that took his life and look backwards, it's going to look bad. But it's like, that's not what we're saying. We're not saying she did, but if you look at it that way, and it's hard to craft these arguments.
Oxycontin. And as a matter of fact, he told, wait, I think this is in.
Can I ask you some specific
Yes.
questions about
Yes.
this? So let's take it one piece at a time here in
Yes.
terms of events after February 14th.
Yes.
In your view, can the court consider Ms. Richins' text messages to Mr. Grossman on February 15th? Can I consider that all?
Can you consider them?
Can he consider the text messages with Corey Richins' lover? Yes, Judge. Yes. And I think he knows it, but I like this judge. It's like, explain to me, if I can't consider them, then it becomes more difficult to provide probable cause for that attempt charge. So I like the question. He'll talk more about this in his ruling.
I mean, I think you can consider anything you want to consider in terms of.
Well, see, that's the question. The Utah rules of evidence say, oh, there's all kinds of stuff you can't consider under these set of circumstances. It's often a difficult slalom course to ski. We did some of this yesterday morning,
Yes.
trying to get a sense from the defense of whether or not the court can consider things like
His mom, that sounds gross to me, but I get it. Some people do it. Did you have to take a nap after? Because I got to be honest, sometimes after I eat a big McDonald's meal, I feel like I'm a little sick and have to take a nap too.
mentioned, quote, if he would just go away, end quote.
So
Or as evidence
Like, what about these damning texts? If he would just go away, life would be so much better. Can I consider those?
of an inference that she wanted him not around anymore.
but that could be divorce. That doesn't
I
have to be death.
understand, and we're not in trial, and I'm not a jury, and so I have to contend with
But how
black
would
letter law. Let me just get this out. I really am genuinely interested in your response. I acknowledge there are multiple credible inferences that can be drawn from this evidence. Several of them innocent, but I'm not allowed to pick and choose. I am not allowed to weigh the relative reasonableness or credibility of the inferences. I'm required to draw all reasonable inferences in the state's favor, to view the evidence as a whole in the state's favor, and identify is there a reading of the evidence that supports a reasonable belief. And so when you say things like, look, this evidence, she went home, I imagine Mr. Bloodworth is fighting yours to jump up and say, that just shows she went home to give her the sandwich. That just shows you went home to give her the sandwich. She went home to give her the sandwich. And so the reason I ask about the stuff afterwards,
Right.
the text messages, her statement regarding ordering the lunch, being home together.
So the text message certainly could be considered for the death, right? Because he's still alive
Well, I
and it's
got that.
February 15th,
But that's not my question.
right? So how does the statement on the 15th relate to something that didn't happen? She's talking about it in the future, right? Like,
I guess the question is, if on February 15th, she has a text message showing a desire to have him not around anymore, why can't I consider that for her mental state on the 14th?
she doesn't say you should be dead.
I know, but we're talking in terms of reasonable inferences here.
It's, criminal defense lawyers look at these phones and it's pretty terrifying to think that someone's going to go back and look at a text that you wrote about your spouse, years later and put it all into a cone of literal death threats when you say, I wish you could leave, he's getting my nerves, I want to leave the house, I'm going to leave him, I want to divorce him. Eric, they put in Eric's divorce meeting with his divorce lawyer. I mean, this was not a perfect couple. They didn't have a perfect relationship.
I don't fully disagree with her there, right? And we talk about that in the Crumbly case a little bit, but there are lines. There are some things that definitely look a lot worse than others. Same thing with Karen Reed and the text messages and the voicemails. It's like, but relationships aren't perfect. People say things that they don't necessarily mean, even really mean things. But it's like what you're saying right while you're doing this thing and buying fentanyl from drug dealers and the context, it definitely gives more than, it wasn't just like, I hate him, I wish he would leave. There's a lot more than just those text messages in this case. I'll just say that.
But to take a context, one single text, and to say that gives you a reasonable belief that she tried to kill him the day before, I don't see the connection at all. I don't think that is a connection.
So I hear you saying you can consider a judgment, it doesn't have any weight.
I don't think it does.
Okay.
So she's telling the judge, you can consider that. I would have tried to come up with some argument why he couldn't. I don't really know what that argument would be. But telling him he can consider it, it already kind of seems like he's considering it to prove probable cause. So the only way he wouldn't get to probable cause is if he couldn't consider those text messages.
Same response regarding her June 18, 2022 text to her friend.
That's what we just said, where she has not seen yet the time. She hadn't had an opportunity to review the timing. So if she maxed up lunch and breakfast, but everything else in there is consistent with what happened that day.
What about her text message on or about February 26th to Carmen Lawler saying something strong?
Again, that's after the 14th.
It's a backward-looking statement, though. Or at least it's comparative.
Well, apparently she had recently picked, apparently according to Ms. Lauder, she just recently got something from her. So
Right.
I mean, that could be not connected to the 14th at all.
Okay.
So,
Or more specifically, not necessarily referring to what you got on the 11th,
Right.
but could be from the 25th.
but I mean, you have a claim that Mr. Richins was poisoned on the 14th. There is no medical evidence. There is no connection. There is no causation. There is nothing.
So like the stuff they have with the actual M1 charge, the toxicology report that proves the fentanyl in his system, there's a lot more evidence there, right? And she's saying, yeah, there's a lot more evidence there. But in this, we don't have that. We don't have any proof that the fentanyl actually even ever got in his system. He just didn't feel good and took a nap. If every time this guy took a nap and didn't feel good, we're going to add an attempted M charge, come on. And you can understand that argument, right? Like every time I've been sick that my wife cooked me a meal or, got really tired and had to go to bed, we could have some problems, right?
But pure speculation that because they believe she tried to kill him and successfully killed him in March, that must mean she tried it before. That is not enough to reach a reasonable belief that someone, and that's the question you asked at the very beginning.
Right.
Just because, it's like a backwards acting in conformity argument.
Yes.
It's a backwards 404B evidence.
This is my question.
Right.
Does that exist?
Which, by the way, 404B's whole purpose of existing in every state in America and in the federal system is exactly to avoid this kind of prejudicial leap of because somebody did something once, they must have done it again. That's the whole reason we have 404Bs, to prevent that.
I acknowledge that. I imagine you would acknowledge as well the numerous exceptions in the lengthy or the deep body of case law regarding exceptions to the general bar to propensity evidence. And so here, when Mr. Bloodworth makes references to modus operandi, he's arguing to some of those exceptions.
Well,
In
actually,
your view, does 404B work backwards, or does it only work prospectively?
it only works prospectively, in my opinion. But the analogy as to why this is such damaging and risky analysis can be found in that rule, baked into that rule that our legislatures and our Supreme Court recognized that that's very, very dangerous to base the prosecution on somebody used drugs once before in their life, they're probably guilty this time. That's the whole thing we're trying to avoid in our system. And that's the whole basis for their argument on the attempt. That's the entire basis because they know they don't have proof. They don't have medical proof. We heard.
And that's not enough on its own. Usually it's not. And I agree with her. I agree with some of these arguments. That's why I wanted to play this for you. I thought some of these arguments made sense. And again, knowing that you're usually going to lose, I still like listening to good arguments.
Testimony about allergies. We heard about all of that. So, there's innocent explanations for everything that happened on the 14th, every single thing. So that doesn't lead to a reasonable belief. They're 100% relying on an actually conformity argument.
I don't think we heard the admissible testimony about abuse, but I take your point.
I'm sorry. I'm trying really hard
That's
to
okay.
separate it in my brain.
I understand.
I actually think it's included in I believe it's included in some of the exhibits. But having said all of that, the distribution charge that is connected to the attempt charge, if the attempt charge doesn't have probable cause, the distribution charge doesn't have probable
I
cause.
agree.
They both have to go.
May I ask you about the consciousness of guilt argument that the state makes?
Yes.
Which I understand to be my words, not the state's. Why is she lying in her text message to her best friend in June about what happened on the 14th?
I think the only thing she got wrong was breakfast for lunch.
Well, I think her location about her being home all day is one of the things that came up. We were working from home that day.
That's easily provable. So it's not like when she's talking to her friends, she's trying to remember the day back, a few months later. And she got part of it right. And part of it wrong. And I just don't know if it's just, how do we know that? What purpose would that be? How would that serve as a lie?
The argument is that she's hiding the fact that she was with another person besides her husband on that day.
Okay, that's a good reason to lie because you're with your boyfriend and you don't want to admit you're with your boyfriend.
Right.
That's not conscious of guilt.
Judge is helping her out a little bit.
Your husband. That's not telling you to tell people you were hanging out with your boyfriend.
Okay, that's one credible inference, right?
Yes.
All right. Would you say that it's not a credible inference that the reason she's lying to her friend is because she had the scheme to be not present?
So why is the judge asking this? Yes, one credible inference is that she was lying because she was with her lover, her boyfriend, her person she was having an affair with. But another credible inference could be that she was lying because of the scheme that she had planned to attempt to do this to him. And if there are multiple credible inferences, I have to give the one that's most beneficial to the state at this point because we're not in front of a jury. You're not proving guilt beyond a reasonable doubt. This is a probable cause preliminary hearing.
But she admitted she was present with him, and she was. She brought him breakfast. So that's true. That inculpates her more than exculpates her. That's the opposite of covering herself. She's putting herself in the house with him on the day that they're claiming he was attempted to be poisoned. That's a statement against interest.
Okay.
In my opinion. Okay. So I don't really need to argue the distribution. You get that. All right. So the only other things that we have on
All right, we're going to skip where she talks about venue and jurisdiction arguments. They were weak. Merger. The judge ends up going and looking it up, and that merging charges, that should be 1 instead of 2. We deal with those later, not now. But I do want to come back and listen to a little bit of the state's argument about the 404B stuff and just using the committed crime versus the attempt to prove the attempt.
Propensity, intent, purpose.
Again, this guy is low. It's like 2 minutes we're going to listen to. Bear with me. We'll get through it. I'll reiterate what he says. It's kind of a quick argument from the state.
Further to many of the exceptions, propensity, intent, preparation, line of accident, nearly all of them. 404B just relates to whether or not the defendant acts in conformity with her character, whether that's prospectively or retrospectively. The most of the defense's argument against Binder was the attempted homicide count. As the court kind of noted, a lot of that goes to a lot of that was arguing countervailing evidence. As the court is well aware, the standard day is notwithstanding countervailing evidence, whether that's countervailing evidence of how quickly Richins eats his eggs, or whether he was shot beforehand or afterhand. It's countervailing evidence. It does not apply to the court's analysis today.
And he's just pointing out, standard is, Judge, you got to give us the benefit of the doubt, basically.
Part of that countervailing evidence, I find it ironic that counsel argued that one piece of evidence from their Richins. What questions does the court have?
I understand the state's position. I understand you to be saying conduct in March is evidence of other acts admissible to prove in MO. I understand the state's position.
And the lessons learned, I think, is very true. We've had some discussion with defense counsel also as it relates to the standards that issue for the probable cause determination. And
All right. So that's the basic gist of what he was arguing, that you have to give us the benefit of the doubt, basically, so they can provide other explanations of these facts. But basically, our explanations are the ones you have to take. At this point, the jury doesn't have to take our explanations. Couple questions here. So has Corey already spent the entirety of the life insurance payout? I have no idea. I don't think she ever got it. I thought they did an investigation, didn't give it to her, but I'm not sure. I've only been following the criminal case. I haven't been following all the other stuff that happened in the background. Adam, why are the rules of evidence so stringent? So we've done a couple segments on videos and videos on this in their entirety. The short answer is the only evidence we want going before a jury is reliable, credible, relevant evidence that tends to prove or disprove something important to this cause. Not something that makes the defendant look bad. Not some other bad thing that they've done. Not something that may or may not be reliable after a game of telephone. This person told this person who told that person, and I'm going to come tell you guys. So we want to keep all of it out if it's even a little bit unreliable. And I think that's how it should be when people's life and liberty are on the line. Reese's mom, why is she trying so hard on this charge? My opinion and guess is she's trying so hard on this charge because she thinks it is her best chance to win. She pretty much knows she's not going to win on the other charges. That's my guess. I don't recall if they have proof of earlier drug purchases. They do, I believe. But most times there is a pattern of poisoning up to death to get the dose right. So we'll see if they have experts to talk about stuff like that. Usually that's not just something some random person can give an opinion on, maybe law enforcement, maybe an expert. Wendy, anyone keep track on the verdict watch on Tellus? So I've been trying to watch that. If you guys see a verdict on Tellus, send me the DMs on Twitter and Instagram. I want to try to go live, watch that verdict together. Why are they taking so long, right? We thought this might be a 15-minute explanation. I think it's the video where it looks like it's somebody other than Tellus in the front seat driving that car. It's my opinion. I don't know. Maybe we'll hear from some juror interviews later. All right. So now we're going to bring up Emily D. Baker / I guess, Recovery Addicts stream. And we are going to listen to the judge's ruling. I think this is a very thoughtful judge, so I'm blocking Emily's face. Sorry about that, Emily. About why did the judge do this? Why did he come down in making the decision that he made? And is he going to find probable cause on all of the charges?
Right. Which brings us to a discussion of what we are and are not doing today.
Okay.
First,
what are we doing?
What we're not doing. We are not determining in any degree guilt at all.
No. He's reminding the audience that this is a probable cause, and I think the judge is very mindful that because this is being streamed, he's going to give his ruling today. It's expected to simply over to trial. So let me explain to you.
Ms. Richins was presumed innocent of all charges yesterday. She is presumed innocent of all charges today, and she will remain.
And we talk about that off the top. This is not that. This is not a jury trial. So it's not guilt or innocence. This is just probable cause. Do they have enough to keep going? Are we even going to set a trial date? Will the state have the opportunity to present this to a jury? If there's no probable cause, judge throws it out. State never gets to present it to the jury. We don't get that far. We don't put the defendant in jeopardy of their life and liberty. None of that happens if the judge doesn't find probable cause. But if he does find probable cause, doesn't mean she did it. So anybody watching this, and I think he almost did it for the media, potential jurors, maybe people watching this, to say, just because I'm about to find probable cause, don't believe or think that that means I believe that she committed these crimes beyond a reasonable doubt. Do not think that whatever I say here means I think she's guilty, because that's not what it is. I appreciate him saying that off the top.
Being presumed innocent of all charges.
He would not say this if it wasn't a media
the court
case.
says today affects her presumption of innocence in any way. Preliminary hearing is a specific thing with a specific legal standard. The state's burden at a preliminary hearing is to show probable cause for each offense charged, and the court must bind a defendant over for trial if the prosecution presents evidence sufficient to support a reasonable belief that an offense has been committed and that the defendant committed it.
I like
So
the
even
judge
though
set
the
the
Constitution
expectation.
provides criminal defendants
Reasonable belief that the defendant committed the offense. Probable cause the defendant committed the offense. Not beyond a reasonable doubt, not guarantee, not absolutely, not that there might not be arguments that she didn't, because there may be arguments she didn't. There may be arguments that a jury could buy. There may be holes in the evidence. There may be gaps in the evidence. There may be inconsistencies in the evidence. All the things that defense lawyers argue in closing argument that could provide reasonable doubt could still be here. That's why he talked about the standard. I just want to listen to it one more time, the actual standard he discusses. Maybe we'll listen to it. Maybe we won't. Uh-oh.
Good afternoon, good afternoon, good afternoon, law nerds.
Let's see if we can find it. All right, here we go.
before the break about the murder doctrine.
He says that there was
His burden at a preliminary hearing is to show probable cause for each offense charged, and the court must bind a defendant over for trial if the prosecution presents evidence sufficient to support a reasonable belief that an offense has been committed and that the defendant committed it.
I like
So
that
even
the
though
judge
the
set the
Constitution
expectation.
provides criminal defendants with a fundamental right to a preliminary hearing,
This is the
the
expectation.
evidentiary threshold of such a hearing is relatively low. At this stage of criminal proceeding, the prosecution need not eliminate alternative inferences that could be drawn from the
You don't need
evidence
to
in
eliminate
favor of the defense. And in reaching the bind-over decision, the court must refrain from assessing whether the prosecution's inference is more plausible than an alternative that cuts in favor of the defense.
All right, there's just an assumption.
Instead, the court must view all evidence in a light most favorable to the prosecution and must draw all reasonable inferences in favor of the prosecution. And the court must leave all.
But not the court being prosecution leaning. It's not the court liking the prosecution more. This is the burden. This is what he has to do. He is forced to view everything in the way that it could benefit the state best and most. That's not how a jury is supposed to look at anything ever. Okay? That's what's important to understand when we have a preliminary hearing and why the state almost always wins. This is why. This is the burden. It's a pretty low bar for the state, especially compared to beyond a reasonable doubt.
Weighing of credible but conflicting evidence to the jury. Here, having reviewed the evidence admitted, including the 1102 statements, the documentary exhibits that were pre-admitted, having considered the admissible sworn testimony of witnesses that testified live, the court reaches the following determinations.
And they're
First,
ordered to answer.
for the reasons described at the detention hearing, which remain valid today, the court had,
He can consider the statements made at the detention hearing.
the prosecution has shown probable cause. The count 1, aggravated murder, and count 3, distribution of controlled substance, both of which relate to events that are alleged to have occurred on or about March 3rd and 4th, 2022, are supported by probable cause. Ms. Richins is bound over for trial on counts 1 and 3.
Remember, count 2 was
With
added
respect to
later.
count 2, attempted aggravated murder, alleged to occur on February 14 of 2022. The prosecution has admitted evidence sufficient to support a reasonable belief of the following facts and events. That in January of 2022, Corey Richins secured a life insurance policy.
This is a circumstantial count, and so the court is laying out the circumstances when taken in the light most favorable to the prosecution ahead of the
Secure his death.
And you can also tell when we're talking about count 2, the other ones are like easy. Yep, probable cause. Count 2 is where we're going to take some time and walk through and document exactly why I am going to say, yes, there's probable cause. And this is going to trial.
That she would do better under the premarital agreement if he were dead, and her business through fraudulent means. That she had a significant financial incentive to secure his death because she would do better under the premarital agreement if he were dead, and her businesses were highly leveraged. That on February 14, she purchased food for them both, including him. She described it as lunch in her text message to her friend in June.
you can eat eggs anytime.
She was not honest about where she was going that day or what she was doing after she left the family home. Eric had a significant reaction to something that day, sufficient to make him consider going to the hospital. He stated,
I think that's a little bit like almost too much in favor of the state. He had a significant reaction to something that day. I don't know.
is admitted evidence that fentanyl can cause a serious reaction. There's significant evidence, at least to support a probable cause finding, that Ms. Richins had secured fentanyl by February 11th, and that on or about February 26th, she contacted her source again and said she needed something stronger.
That part,
These facts taken together would support issuance of a search warrant to investigate whether Ms. Richins had attempted to cause the death of her husband. They would support issuance of an
It's enough for a search warrant, which is also probable cause.
arrest warrant for her arrest on attempted
Arrest warrant, probable cause.
murder, and they are sufficient to support bindover under the probable cause standard for attempted aggravated murder on February 14th.
And he's not the first judge to rule this. I assume the other ones were done by other judges. If not, then even more so, we knew he was going to say yes to this. So no surprise there. But it was interesting to hear him lay it all out. The financial incentive, the conversations with the drug dealer, with the boyfriend, the reaction that Eric had, the comments Eric made that we know through the text messages.
2022.
so he's holding her to answer on
The
count
court
2.
makes this determination without considering the probable cause that indicates that Ms. Richins actually caused the death of her husband.
So he's not
I love that he put that on the record, that he's doing this without even needing to know the deed was completed later, because that might be inappropriate. That might not be something he should consider. That might be propensity type evidence. So I appreciate that he did this because he's cleared up an appellate issue for the state. He's like, listen, we don't even need all that. The text messages, Eric's response, that she gave him food, the financial incentive, the comments she made after, all of that's enough.
taking the murder into account.
So
A jury will be
while
able
he is
to.
considering evidence.
He's taking
of
up the
statements made
circumstances
by Ms. Richins and actions
before and
taken
after the
by
action,
Ms. Richins
before
after February 14th. It is not that action. That is the
But not the
alleged
murder.
successful completion of the attempt. Rather, the actions and statements the court is considering that occurred after February 14 are her text messages to her paramour to the effect of, I wish he would just go away, or if my husband would just go away.
Those texts are pretty bad.
Contact with her source of controlled substances, seeking something stronger, which leads a reasonable inference that the
Job's
stuff
not
she had
done.
before did not give her the results she wanted.
Yep.
And her statements on June 18, 2022 to her best friend that she provided a lunch. And this,
She
of course,
gave him the
includes the
sandwich.
evidence from the morning of February 14 that she did, in fact, buy food from Mirror Lake Bank. Taken together, viewed in the evidence in the light most reasonable to the state, drawing all reasonable inferences in the state's favor. This evidence supports a non-speculative inference that Ms. Richins attempted to murder her husband with fentanyl on February 14th.
It can't be pure speculation. That's why he said non-speculative.
Having drawn that determination, it also requires the court to bind her over trial on count 4, which is the distribution charge related to February 14th. We pause there before we get to the financial charges. Mr. Bloodworth, did you need clarification of the court's ruling? So
No. We with or the district.
9 and 8, insurance fraud with respect to the $250,000. Count 6 and 7, mortgage fraud with respect to
Now we get to the financial crimes. Will he find probable cause on these? These are some of the easiest ones.
the Iron Bridge loan and the Boomerang Finance loan, respectively, are bound over. Counts 7 and 8, insurance fraud with respect to the $250,000 True Stage policy, and then a scheme with respect to the $100,000 True Stage life insurance policy, respectively, are bound over. What's that business?
think you just said 6 and 7 and 7 and 8, and you skipped 5.
5.
My apologies, 5 and 6 are
She's
Iron
correct.
Bridge Boomerang, respectively.
So the record will be clear.
Are the $250,000 two-stage policy and the scheme related to the $100,000 true stage policy, respectively.
Right, and then we're going to get to the 3 forgery
9,
counts,
10,
9, 10, 11.
forgery counts related to the
We got to make Peter and EDB together again in reality. We need to make that happen. We'll make it happen soon. I know you guys have been asking for it. I'll ask her to come on soon.
Alter, America First Credit Union.
I just hate bothering other people and like asking them to come on and take time out of their day. That's why, I don't ask a lot of people to come on and do this stuff, and because it takes forever and I try to get it in an hour. We're right at an hour now. We're almost done. Just a couple more comments. I'm going to answer a couple questions. Yes, this is my stress guy for today. This is, I need it. I need it. He's been getting a workout.
Account statements submitted in respect to the Iron Bridge and Boomerang finance loans, and with number 11, the forged signature on the $100,000 true stage life insurance application. Mr. Bloodworth, any clarification?
No, sir.
Ms. Nestor?
Yes, sir.
Okay. Let's pause there for a second.
So that's it. Probable cause on everything. She's being held over. They set trial dates. I think it's like next spring or summertime. I think it's at least 4 weeks. I can't remember. They may add some for jury selection. So that's a trial also on our horizon. If you guys want to cover the trial and continue to have me cover the case, let me know in the comments and hit the like button on this video. Of course, Reese's mom said, why is that the case? I probably missed when this was happening. So I'm not sure. Hopefully I answered your question, Reese's mom. I apologize for that. Do we know if the affair will be admissible? Yes, they will be able to talk about that. Absolutely. It's intertwined. It's part of motive. Those text messages I feel like are going to come in. Patricia, I'm late to Miss R. Who's paying her lawyer? So she had her own lawyer. They withdrew, and now she's got public defenders. So the state is paying her lawyers. All right. That's all we got. I appreciate you guys so much. Thank you so much for joining me. Hit that like button on your way out. Make sure you subscribe. I'm going to take 2 minutes to just tell you about what I did today and why it's frustrating. We bought all this new stuff, trying to set it all up, trying to get it all set up to make it look good, sound good for a new podcast that we're doing. Still on Lawyer You Know channel. We're going to talk more about it. It's launching in a couple weeks. Some different special guests, some people that you know, some people that you don't know, some people you've seen, some people you love. A lot of people I love will be on it. So we're trying to get 2 people in the same room with the microphones and all of it to look and sound good. It is so hard. Yes, those 2 chairs are where we filmed our first podcast episode, but kind of determined it didn't look exactly how we wanted to. Sounded awesome. So we'll probably still use it for a podcast. The way it looked wasn't amazing. So we're thinking about other options potentially, or just to scrap it. There will be some podcasts where I'll be like this. It'll be virtual and somebody else will be on the screen and stuff like we did before, but it's going to be cool. It's going to be different. I think you guys are going to like it because it's going to hit on something you always ask for and I'm never really able to do, just time-wise and being able to dig into different things. So I know that's kind of vague. We'll definitely talk more about it. I wasn't even like planning on it's not like a tease or anything. I'm just really annoyed at how it all turned out and how we're basically sending everything back that we got, or 90% of it. And we'll see where we go from here. I just kind of want to be like, forget it. Just do it like this always and not have any other setups, but growing and changing and all that stuff is always hard and annoying, but we'll continue to do it, especially if it's fun. And hopefully you guys like it. If you don't, I'll send it all back anyways and just get back to basics. So thanks for being here, but now I'm really out of here. We did about 3 minutes of overtime. Till next time, peace. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.